The subcommittee chair.
I thank the chair. And so when you think of all the rules that have already come out and all the regulations that are proposed and the mounds of paperwork that has come out in just a short period of time, with these agencies not specifically funded to the level that they want to be funded at, I can only hazard a guess what we would be looking at right now if they had all the money that they really asked for. I guess the takeaway from this hearing so far is, from the other side of the aisle, the solution to all the problems that we have is simply spend more money on it. And I guess the takeaway from this side of the aisle so far is the solution to the problems is we want to get it right as far as the rules and regulations that these agencies are promulgating. If you look at past history, if you look at Reg NMS, and you compare that to what we're doing today, now that was regs and rules coming out of law of around 80 some odd pages. We're looking at 1,000 some odd pages. That took, I'm told, from 4 to 6 months from rulemaking period of time here. There they did it for approximately 15 months. And there they took over, I guess, over a 3-year period of time to roll them all out and actually get into implementation. Here we're compressing this into a much, much shorter period of time in a much larger area of the environment, where we're going to ask the industry to come up with an entirely new architecture structure, build new complex new technology systems that they don't have yet, create a whole new operational process they don't have yet, a whole new legal documentation process that they don't have yet, creation of new clearinghouses, CEFs, connectivity between all of these entities. All that wasn't there in the past. You're trying to do it now in an extremely expedited manner. So it goes to the point I raised before. If we do it in the way, in the time frame that you're talking about now, won't this lead to either a seizing up of the derivative market? Won't it lead to a sending of the derivative market overseas? Or at the very least, won't it create unfair advantages between the big players in the marketplace and the very small players who cannot simply keep up with what you're trying to do? I'll leave that to Mr. Gensler.
We've asked, in the midst of each of these rulemakings, and we've asked more generally to hear from the public on the phasing of the implementation. Congress allowed us some discretion, both agencies, that no rule should become effective sooner than 2 months after this July date that's the implementation date, but it could be later. So for the same reason that you just raised, Congressman, is to hear from the public as to what rules can be done a bit sooner, which rules need more time, because there is a cumulative cost of this. It is a paradigm shift, as you were referring to, and I think we want to, as you say, get it right.
Sure.
I would agree with that. I think unlike the statutory deadlines that we've been working through, we have much more discretion with respect to the implementation timing and sequencing, so that we can put the rules out and make them effective in an order that actually makes sense for the industry, in order to build systems, develop compliance.
Right. So can both of you, realizing the feedback that you're already getting on all those points, can both of you sit here today and tell us that you would like Congress to give you more time? Because we know we have a deadline in July. Do either one of you think that you can do this appropriately and meet the deadline of July and still have fairness to the marketplace that we're talking about?
I think we actually already have the discretion on the implementation.
On the implementation, but how about the rule promulgation?
I feel that with the significant crisis of 2008, which was a very real crisis, and the excellent staff at the CFTC and commissioners, what timing has been put out there is doable. We're human. Some of these will happen after July, no doubt.
Well, that's not in the statute.
It's not like a firm deadline that I understand. We're going to get this right, and some of these will be after July, but we're also going to take up final rule writing in the spring and summer.
Well, I mean, one aspect of it, and I'll ask both of you, this is in President Obama's executive order instructing certain federal agents to review regulations to ensure they do not stifle job creation and make the economy less competitive. This doesn't apply to either one of you, I don't believe, by the executive order, but is it part of your process that you're going through that you wish to comply with that executive order so you make sure we don't stifle jobs and we don't hurt the economy? I'll start with Ms. Shapiro.
Sure, Congress, as you and I have discussed, the terms of the executive order don't apply to the Securities and Exchange Commission, but we've determined that it makes sense for us to try to act as though they do. I should say right off the top that much of what's in there we already do. We already comply with the Paperwork Reduction Act, the Regulatory Flexibility Act.
So you're going to try to comply with it?
Cost-benefit analysis. But in terms of being able to go back and look at some of the rules that have been around for many, many years and see if they're having an unintended consequence given all the changes in our economy and in technology in particular, we want to do that. We want to look at the impacts on small businesses. And we've been very focused in our rulemaking over the last year in particular to make sure that where we can give delayed compliance dates for small business, we're trying to do that and be as accommodating as we possibly can.
Mr. Gensler.
We took a very close look at the executive order. Our practices are consistent, though in one place Congress in our act has given us how to do cost-benefit analysis. It's called 15A of our act, so we have to follow congressional mandate rather than an executive order. In terms of looking at our entire rule book, we do plan to do the 120-day plan where we would tell the public how we're going to look at our entire rule book, even if it's not related to Dodd-Frank.
Thank you, Mr. Garrett.